what do you do to make something happen that has already been ordered by a judge? For example, there is a joint letter of instruction in order to instruct an expert. That needs to be agreed, and people can't get to an agreement about what goes in the letter. That is something you would submit to the court, not strictly for enforcement, but for a determination after you've already had an order about the sort of big picture side of it. In the first case, my advice would be is that you agree with the other side that this is what I say about the joint letter of instruction, and this is what you say about the joint letter of instruction. Let's submit both to the judge for the judge to decide. Now, that is likely perhaps to be something that you would agree to share the cost of, because you simply can't agree. And it's probable that you didn't canvass the exact ins and outs of it in the hearing beforehand. The second scenario, a Form E, for example, is not being filed with all the appropriate documents. In that case, what I would do is I would, on a D11 form, ask the court for a penal notice to be attached to the paragraph number of the order that says, and you will file Form E. You must also ask for your costs, because that way you get £7.50 an hour if you're in person, or the costs of your lawyer in doing this. In my experience, they will simply grant your penal notice. The penal notice will say if you, the naughty person, does not file the Form E in 14 days, then we'll be having a contempt of court hearing, which could mean a fine, could mean prison. It's pretty serious, and it gets people moving like you wouldn't believe. Third scenario, enforcement over a final order that somebody is simply refusing to comply with. But what you want to do is you want to make an application for enforcement on a D11. And perhaps what you might say is I'm going to ask the judge to simply sign the papers to give me sole conduct of the sale, because he won't even cooperate with the estate agents, and I want my costs of doing so. The other route you could go down is something called contempt of court, because you can simply say this person is in breach of an order, that's contempt of court, I want him punished. That's not the same as getting all those powers of sole conduct, a judge will sign on your behalf. So it's not quite the same thing, but it's pretty scary. It is much more difficult, however, to get contempt of court proceedings, and I would leave those right down the line, because if you're going towards a contempt of court situation, it's usually pretty heavy and things have got pretty serious.